Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled United Arab Emirates Maritime Claims and Limitation Funds. Limitation funds in UAE. As with most of the world's trading countries, the United Arab Emirates has embraced international conventions in its national laws, which is certain conditions allows carriers such as ship owner to confine their liability for claims made against them. Archaeologically, the reason for letting ship owner limits their liability was for policy purposes. To be specific, to encourage the international trade by sea. The value of claims emerging from maritime occurrences. For instance, the loss of rate could exceed the cost of the vessel and ruin a ship owner. International conventions obliging the limitation of liability. Therefore, aim at looking for a balance between sufficiently paying a claimant for its loss and allowing owners to limit their potential liability to a sum that can safeguard the interest at a reasonable cost. In the UAE, Article 138 until 142 of the Federal Law Number 26 of 1981 of UAE Maritime Code entitles an owner, charterer or worker to restrain the liability given the size of the vessel. So this article is meticulously in light of the 1957 International Convention relating to the limitation of liability of the owners of seagoing ships. This agreement, be that as it may, was superseded in 1976 by the Convention of Limitation of Liability for Marine Claims, the 1976 Convention. It was by and large acknowledged that the 1957 Convention required updating, and the 1976 Conference was acquainted with widening the types of cases subject to limitation, increment the point of confinement of liability, and re-examine the test of conduct barring a litigant from its prerogative to restriction. Under the 1976 Convention, the privilege to limit liability expires only when an applicant can demonstrate willful intent or recklessness concerning the individual looking to constrain. The privilege to restrict liability under the 1976 Conventions, as far as anyone is concerned, was under aviation infraction in England just once since 1976. In this case, the master, who was likewise the proprietor of an angling vessel, purposely and frequently caught up with transportation path before different ships in the English Channel, in explicit contravention of the movement division scheme, keeping in mind the end goal to be the first and touch base at lucrative angling ground. Amid the two intersections there was a collision. The master knew the hazard he was taking, the danger of an impact, however, all things considered, purposely took them. It is evident that the expectation of the 1976 tradition To be specific, that it will be break the privilege of limiting extraordinary conditions. Ships by nature of their exchange are involved in events that lead to claims. This claim may be for personal injury, damage to property such as other ship, or fixed and floating objects such as drifting items or cargo damage, to name a few. A ship owner may be exposed to extensive loss, even to the extent of insolvency, as a result of claim. In acknowledgement of the essential and necessary role played by ship in endorsing world trade, ship owners are permitted to restrict their risk for application in individual countries, subject to certain conditions. Such constraint is allowed by international conventions such as the 1976 Convention on Limitation of Liability for Maritime Claims. Since 1957, as the value of consignment, container docks and installation, and the like vastly augmented, and claim arising from marine debt similarly escalated, many claimants felt that the limit enforced by 1957 convention were irrationally low. So in cases where the limitation of liability was likely to be intricate, expensive, and time-consuming, lawsuits often resulted to break the fund. Also since 1957, as some of whether conventions have some into effect which has dealt with liability in specific field. For instance, the Civil Liability Conventions on oil pollution convention, such as the introduced monetary limits for the particular category of responsibility much superior to the overall limit administered in the 1957 convention. To avoid either in general or under specific circumstances, the convention limits annulled by much lower worldwide limits of the 1957 convention. Modifications are always necessary. In addition to mollifying the desire of probable claimants for higher limits, the change was needed to make more confident prerogative to limit liability. The product of this need for modification is the 1976 Convention on the Limitation of Liability for Maritime Claims, or the 1976 Convention. What is limitation of fund? The term limitation of fund indicates a guarantee or deposit made by ship owner to meet any damage claim, and the ship owner has to calculate it on irresponsible ships with or some tons. Limitation or fund is a legislative amount to fix the constitutional limits of liability of ship owner for the negligence of their captains, officer, or the operators. World nations have entered into an international agreement between the countries concerning the limitation fund. Many states permit a ship owner facing a permanent negligence claim to deposit an amount with the court on non-biased basis until a decision has been effected. An economic value limited and calculated concerning the density of the ship. Archaeologically, the purpose of allowing ship owners to limit their liability was for policy purposes, specifically to boost international trade by sea. The deposit constitutes sole source of the monetary limit of the ship owner's liability. In what follows will be a comprehension of how it is possible for a ship owner to set up a limitation fund in the UAE. So that's all the article. Bye bye and see you on my other video. Bye.